The August 10th, 2011 meeting of the Lowell Conservation Commission. Kindly remind you, if you have a cell phone or a pager, to kindly turn it off. If it goes off during the meeting, you'll be asked to leave. Moving on to business, we have the first two items, and we may take them together, but I'm going to have Craig fill us in on them, but let me call them. First item is an enforcement order, Phoenix Avenue LLC, care of Frank Matthews. Violation location is 55 and 89 Phoenix Avenue, and it's filling in bordering land subject to flooding, which is the 1% 100-year floodplain. I won't call a second one yet. I'll just call that Craig. If you can fill us in as to what's going on here.
I have a short PowerPoint I can show with some very simple photographs. This issue was brought to my attention from another city employee, I believe, on July 29th, the day the enforcement order was issued. At that time, I went out to the site and observed, so very briefly, this is the site locus and resource areas. You can see Rogers Street that runs roughly horizontal across the screen, and Phoenix Avenue that goes north to south with the wetlands and considerable floodplain in the vicinity of the building at 55 and 89. On July 29th, photos taken from the abutting property with the permission of the landowner. This is not quite so clear, but the next photo you can see large piles of earth have been placed in the flood area without any method of securing them against erosion. Here again, you can see them in their relative location to 55 Phoenix Avenue. At the time, I actually observed trucks placing dirt in the area. So the enforcement order was issued both against the landowner and against this trucking company. And they actually followed the truck back to where the earth was coming from, which was a subdivision in Tewksbury. Subsequent to that, after I issued the enforcement order, the trucking company, Foster Contracting, has contacted me on several occasions to discuss the matter, and it indicated that the earth was moved. This is this past Monday, the same area. You see a dumpster, but no soil remains. Again, relative to the building at 55 Phoenix Avenue.
Then if it's okay with the rest of the commission, I'm going to also call the second part of this, and it's an enforcement order, Foster Contracting, 92 Jocks Road in Tingsboro. The violation location is also 55 and 89 Phoenix Avenue. And again, it's regarding filling and bordering land subject to flooding, the 1% or the 100-year floodplain. Do we know, Craig, what happened to the piles that were brought onto the site?
Where they were moved to?
Yes.
I do not know. I have not been in communication with the landowner, and the contracting firm, Foster Contracting, indicated that they were a subcontractor for this project, and they had communicated with the general contractor who was overseeing the work, and that person, who I have not spoken to, nor do I know, had taken care of it in conjunction, I believe, with the landowner.
All right, and when did you do the follow-up site visit?
This past Monday.
All right, was
two days
there
ago.
evidence that the piles had been distributed along the site?
No, from where these photos were taken, it looks that the overwhelming majority of the material was removed. As we have an active project across the street, I'm fairly familiar with the area, and that portion of the site is heavily compacted sand and gravel, and I did not see any evidence that that had been disturbed in the removal. Again, that was referenced in the enforcement order as one of my concerns, that the removing the material would also require a certain amount of care to avoid anything, especially with the storm events that we've had running into the adjacent stream area.
Was there any evidence that that had occurred?
No, again, it looks to be fairly cleanly removed, but I was not involved in the removal, and I did not access the property, so I can't confirm that.
Well, you had indicated that the contractor did not contact you, but did either the landowner or Foster Contracting contact you prior to removal of the piles?
Again, Foster Contracting spoke with me when the owner received the enforcement order to discuss the options. They'd indicated they would talk to the general contractor and determine what might happen with the material when it may or may not be removed, and would keep me informed. Subsequent to that conversation, but before these photos were taken, the owner of Foster Contracting had contacted me and informed me that the material had been moved. Again, I have not spoken with the general contractor for the project or with the landowner about the circumstances under which it may or may not have, under which it was removed.
All right, I'm going to open it up to the rest of the commission for questions. Commissioner Lovely?
In your opinion, Craig, from what you've seen, does it appear that the whole issue's been resolved?
The issue, and this is always a little bit complicated with an enforcement order, that I try to write them very clearly so it's clear what the issue was and how it can be resolved. This issue was directly related to the placement of the material in the flood zone and my additional concerns then with its removal and the steps that were taken to ensure that its removal was done appropriately. As to the piles that have clearly been removed, as to the method of removal and any effects that may or may not have had, I can't speak to that.
Is there a way for us to formally close it out with the property owner?
The next steps are at the will of the commission. These have been handled before. They can be left open. We can try and request more information. If the commission is satisfied that the matter is closed, then in the past the commission has voted to terminate an enforcement order, or if it, for the purpose of an ongoing conversation, they have been left open. For example, I'm sorry, I can't remember the site, but one of the last enforcement orders we've had, we left it open for 6 months to revisit the issue. It was, the remediation was completed, but we wanted to come back and speak to the landowner in 6 months.
So it is possible to leave the order open, but not require anything further, but as an opportunity, it would serve as an opportunity to kind of verify that this type of activity wouldn't happen again with the same person who was in violation?
Yes, I believe that is one of the options available to the commission.
Right. No further questions. Thank you.
Commissioner Chalupka?
Do you know why the earth was moved there from the condominium?
Again, I haven't been able to speak to the general contractor or the property owner or anyone involved with the what appears to be a subdivision in Tewksbury. Again, I had no real reason to follow up on the subdivision, what their plans are there. And the clearest communication I've received has been from Foster Contracting, and the owner simply said they'd been contracted for a small portion of the work. They completed it, but that they were eager to work with us to let us know what they knew.
So you don't anticipate that that's going to be happening over and over again?
I honestly can't say.
Yeah. I noticed that you requested erosion controls after the dirt was removed. Can we assume that that did not happen, or is the site already erosion controlled?
Again, I don't, on my follow-up visit, I did not see a lot of the original material still in the same location that was visible from the public way or from the abutting property for which I had permission to pass. That said, also could not see any form of erosion control that had been used or evidence that one was still in place.
Commissioner Varnum?
No questions.
Commissioner Mellon?
Yes. So there's, again, this one has a fair amount of information. And there's two pieces to this. One, I set a deadline of today to remove all material, and according to the enforcement order, it's subject to approval of the commission. But then the subsequent items, conduct a site visit to ensure that material has been removed and no sediment has entered the bordering vegetated wetland. If wetlands have been altered based on the site visit, a restoration plan shall be submitted and permanently secure site against erosion. Those follow-up conditions were all to be completed by August 20th.
Well, I guess my question is, what's violator number 1 and violator 2? Are these two different
Again, it's
forms for violator number 1 and violator number 2?
It's issued against both the property owner and the contractor involved in the violation, but it's the same enforcement order. They're listed as two different orders on the agenda because they are two separate votes, but it is effectively one order.
Well, in reading, the longer of the section 2C, my recommendation would be to have a site visit and see what is going on out there. And make it clear in our own minds as to what the violations are and what the responsibility is on each of these two agencies, the property owner and the subcontractor.
Commissioner Lynch?
Craig, do you think we're actually going to be able to get on site to see where the fill was placed or removed from? Or do you think we're going to have to go off-site like you were and check out the conditions?
I believe the most straightforward way to approach this would be to ask the landowner. In the absence of that, I don't believe an enforcement order gives us the right to pass upon their property. An order of conditions or a notice of intent filing would. In the absence of that, there may have to be an attempt to view the property from the nearest neighbor if possible.
Do we have, the long and the short of it is the particular landowner involved here, Phoenix Avenue LLC, and Mr. Matthews has been before us regarding other properties of his or this particular property. And I think I don't want to speak for him, but he's fully aware that these properties are within floodplains, and there are floodplain issues, and that there are bordering vegetated wetland issues. All you have to do is open your eyes to be able to see that. It's fairly clear that there's wetlands issues out here. What troubles me, I'm not sure whether or not Mr. Matthews knew this was going on or not. It appears from Phoenix Ave to be a somewhat derelict site, but with the number of trucks, loads that looked like had been dumped there. I can't imagine that the landowner was unaware that this was going on. I, for one, would like to conduct a site visit. You cannot see the back of this site from the street. It's not visible. I don't have any information before this commission or that has satisfied me that the piles were not otherwise just moved to another location on the site. If we're not, we have in Commissioner Lynch, we have methods to be invited, I suppose. You know, a violation was observed. We have an enforcement order before us. We can proceed with ratifying the enforcement order on motion in its entirety against both violators. At the same time, we can also discuss the levying of fines until such time as the rest of the enforcement order is complied with by the violators 1 and violator 2. Those can occur on a daily basis until such time that the violators fully comply with the enforcement order as issued. We have to take it up for ratification, and I'd like to discuss that, but in order to satisfy this commission's outstanding questions, whether or not whether or not the enforcement order as proposed has been fully complied with, I think that the landowner and the contractor need to come before us. Records are kept, bills of lading are kept with these trucks. They can't just go from point A to point B and dump off a load without keeping some record. These are all under commercial licenses. They have to show, where they've moved loads to. The drivers are personally responsible for that under their CDLs, and the companies that employ them are also responsible for that under their CDLs. So as far as evidence of what happened to these piles, I think that can be furnished by violator number 2. As far as violator number 1 goes, which is the landowner, we can discuss options. But they have until the end of next week to satisfy us that the order has been complied with. Again, we can't just enter upon the property, but a large part of this property is not visible from the street. So, is there any further discussion from the commission? All right. Do I have a motion to ratify the enforcement order as issued by our administrator?
So moved.
Do I have a second?
Second.
All right. Is there any further discussion on the motion? All in favor? Commissioner Lovely?
Aye.
Commissioner Chalupka?
Aye.
Commissioner Barnum?
Aye.
Chair is yes. Commissioner Mellon?
Aye.
Commissioner Lynch?
Aye.
None opposed? It's unanimous. Now, the motion has been ratified. I noticed that we have a in the gallery, Mr. Leo Garno. Mr. Garno, are you aware of this?
Yes, I am.
All right. Would you like to speak on behalf of this, or would you choose not to?
At this point, I choose not to.
All right, that's fine. Now, what I would suggest, Craig, is that you get in touch with Violator 1 and Violator 2 on the order with respect to the issue that's been discussed, and indicate to them, and we can put this in the form of a motion to amend the enforcement order to include additional requirements, and perhaps we should do that, but I think it's prudent at this point in time that that it's made clear to the landowner and to the contractor that the commission is requiring proof and would request a site visit with the landowner's permission in order to determine and satisfy the commission that these piles have not been otherwise located on the site. Am I correct, Craig, is that this entire site is below the 1% or the 100-year floodplain?
If you look at the map I provided, again, I apologize, it's not as clear as could be, but the vast majority of the property is within the 100-year floodplain. If you look at the location of the orange, again, the floodplain, its relative distance to the property line to the south, that corresponds roughly to as much of the building in the rear as we can see, if not more. So almost all of this photo is in the 100-year floodplain.
So pretty much the areas that are not visible from the street are resource areas, either floodplain or bordering vegetated wetland.
Overwhelmingly so, yes.
All right, and those are the areas that we can't be satisfied whether or not the piles were moved otherwise on the site. All right. In that regard, any further discussion from the commission? Yeah, Commissioner Lowell.
With regard to violator number 2, I would think that you'd be able to get loading slips. You know, there are certain Department of Transportation regulations that require truckers to provide, quantities, volumes and weights of material they're transporting. I think that would be something that we could request violator number 2. They could easily provide that, and that would be a way to kind of get a better sense of the quantities of material that were potentially disposed of on site.
Yeah, so what I have down for the discussion here is to contact both violators with respect to the trucking contractor to request a bill of lading or otherwise loading slips with volumes and weights of material, and to contact the landowner and or their representative and request a formal site visit to ensure compliance with the full enforcement order.
Commissioner Lovely, am I correct in understanding that would be for the material placed both on the site and the material removed from the site? So
That would be
it would
correct.
be a double checking against each other.
Absolutely, and the current enforcement order is silent on that request, from the trucking company. So I would suggest maybe a motion to amend the enforcement order to include that request, in addition to the request that's already on the order, which is, the site visit from the property owner.
Is that a motion?
That's a motion.
Do I have a second?
Second.
Open it up for discussion then. Commissioner Chalupka? Commissioner Barnum? Commissioner Mellon?
No comment.
Commissioner Lynch?
No comment.
All right. Without further discussion then, all in favor of Commissioner Lovely's motion to amend the prior enforcement order, or should I say enforcement orders? Let's take it up as enforcement order. All in favor, Commissioner Lovely?
Aye.
Commissioner Chalupka?
Aye.
Commissioner Varnum? Chair is yes. Commissioner Mellon?
Aye.
Commissioner Lynch?
Aye.
All right, and then finally, can I have a motion that that the ratification and the amendment apply to both violators and be taken as, and that the order apply to both violator 1 and violator 2?
So moved.
All right, do I have a second?
Second.
All in favor, Commissioner Lovely?
Aye.
Commissioner Chalupka?
Aye.
Commissioner Varnum?
Aye.
Chair, yes. Commissioner Mellon? Commissioner Lynch?
Aye.
All right. None opposed. Vote is unanimous. All right. Moving on. A request for certificate of compliance continued from previous hearings, NAM-ON, concerning DEP file number 2060613. The project location is 1519 through 1527 Middlesex Street, also known as the U Plaza. If I could have you identify yourself for the record.
For the record, my name's Jack Sullivan. I'm owner of the Sullivan Engineering Group. And basically, this is a continuation of our last meeting for a request for certificate of compliance. There were a few additional items that the commission requested that NAM-ON looked to install at the site. These items were 6 additional concrete bumper stops were to be added along the rear pavement area to protect the swales. Some no snow dumping signs and posts were to be installed. The wire mesh covering over the flared inlet on the 24-inch drain should be secured. And again, all weeds were to be removed from a riprap basin. All these items were completed. There was a site walk on Monday night with some members of the commission and Mr. Thomas, and the city engineer was on site as well. The one item that the city engineer requested, she liked the idea of the additional concrete bumper stops to protect the swale, but she was concerned that people might view these as parking spaces and look to park head-on against the bumper stops. She asked she asked for some recommendations on what could be done about that. I suggested either stenciling no parking or to paint the concrete bumper stops yellow. It was basically decided to paint them yellow. Mr. Ahn painted them Tuesday morning, and Mr. Thomas verified that today at the site. So we made the suggested recommendations that this commission made, and the as-built plan reflects those changes.
Are there any comments from the commission? Commissioner Lovely?
I was on the site visit Monday, and I concur with everything Mr. Sullivan's saying in terms of compliance with the conditions that were outlined.
Commissioner Chalupka?
I agree, I'm satisfied, as long as the additional 2 requests that the city engineer made are met, that the annual report is filed with engineering and that you provide the contact info for the responsible party.
Commissioner Varnum?
I think this project is finally complete and hopefully will be working properly.
Commissioner Mellon?
I was at the site visit Monday evening, and I concur that they did what we asked them to do in the order.
Commissioner Lynch?
No comments.
Craig, anything further to add to this?
Only to verify that I did drive the site today and that the bumpers were painted in an appropriate way to make clear that they should not be used as a parking area.
All right. Do I have a motion on this?
Move to issue a certificate of compliance on this project.
Do I have a second?
Second.
All in favor? Signify by aye.
Aye.
Are there any opposed? The ayes have it. All right.
Thank you very much.
Thank you.
Thank you.
Thank you for all your work
Thank
on
you.
this, too. Moving on, notice of intent also continued from a prior hearing, Lowell Regional Wastewater Utility. regarding DEP file number 2060677. The project location is 500 Wentworth Avenue, which is a linear project, and it's a drain pipe repair in bordering vegetated wetlands and bordering land subject to flooding, the 1% of the 100-year floodplain. The commission has been or is in receipt of an email requesting a continuance on this, I believe, or a note from Shannon Cohen. That's correct, Craig?
Yes.
Okay. I know, Mr. Garno, I know you would like to be heard on this matter. You've submitted a letter. Was that with respect to this project, or was that? Okay. If there's anyone else here regarding this project, and this is the city's working behind 500 or near 500 Wentworth, I'm not going to hear any evidence tonight because all parties are not present, in particular the proponent's not present. So this is going to be continued to the next meeting.
May I make a statement here? In regards to
Mr. Garner, if you could identify yourself for the record and speak into the microphone.
Okay. My name is Leo Gano. I'm with Northeastern Consulting Forestry. I represent Mr. Frank Matthews regarding this case. What I found online was a complaint I filed against 500 Wentworth Avenue. I think that was erroneous. I had sent an email asking for questions on Tuesday, July 26th regarding the application itself by the Lowell wastewater utility. And I think the complaint was filed as part of the notice of intent, which is in error, because the complaint was against 500 Wentworth Avenue for ongoing work without a notice of intent. There are two separate items there.
All right, you have me confused, so.
I do my best. The first thing is on July 26th, I sent some questions to Craig Thomas regarding the filing of the notice of intent where there was, in my opinion, there was data missing in the original filing. And that was that the property owner was not filled in. In all my years as a wetland scientist, I have not ever seen the word linear. I've always seen somebody's name or a list of names. I've handled water lines and sewer lines being installed, and every landowner who's involved has their property listed. And that is, these things are numbered, and Mr. Thomas has that email I'm sure that he could make available. There were questions specific to the filing itself as to the lack of information. And what I saw online was the complaint regarding work being done without a notice of intent filed or a permit from DEP at land on or next to 500 Wentworth Avenue. I submitted photos with that complaint also. And I believe some of the work is done on Mr. Matthews' property, particularly fill in the wetlands. Thank you.
All right, thank you. All right, yes, Attorney Barton? Yes.
My name is Stephen Barton, and I also represent Mr. Matthews in connection with with an ongoing piece of litigation which I want to bring to this panel's attention, which I think it factors directly on the notice of intent with respect to this project.
Now, which notice of intent are you referring to?
Notice of intent to do maintenance work and install some additional drains to that pipe which runs on the boundary line, which apparently there's an easement to the city, which I've never seen, which empties out on Mr. Matthews' property. By way of background, there was a lawsuit in 1979, which was settled in 1985, involving Mr. Matthews and the city of Lowell. Yes, sir. I'm sorry, sir. I've never been here before, so my apologies in advance. Okay. There was a lawsuit in 1979, Maurice Broussard versus Frank Matthews, that had to do with water or storm water being drained onto Mr. Matthews' property through this particular pipe, which empties out here into wetlands which are on Mr. Matthews' property. At that time, or at 1985, there was a settlement. In that settlement, the city agreed to build a pipe rediverting that water across Mr. Matthews' property and across Phoenix Avenue to a culvert on Phoenix Avenue. Essentially, the city had been taking Mr. Matthews' property and using it as part of its storm drainage system, a de facto eminent domain taking without compensation. In the period of time between 1982 and 2002, as a result of this almost artificial dumping of water onto Mr. Matthews' property, there's been about a 25% increase in the percentage of his property, which is now wetlands, diminution in value as well as use. Currently, in 2006, Mr. Matthews brought suit against the city because the spirit of this particular agreement was to not illegally dump stormwater onto Mr. Matthews' properties and for the city to divert that into the city's mainline drainage system. Since then, and part of the agreement was Mr. Matthews was supposed to draw up a plan. There is a plan in existence for this, and that the city would do it upon completion of this plan and Mr. Matthews obtaining EPA permits, which he did not do because it's impossible for him to do that. Since then, I believe the city has undertaken to get permits pertaining to this particular outage on Mr. Matthews' property as part of a grander scheme, a public works project, have you. Currently, the case is pending. The next date on the case is October 27th of 2011. What Mr. Matthews has filed a preliminary injunction attempting during the pendency of this case or further pendency to enjoin the city from dumping water at the site, the precise site which this particular notice of intent is attempting to clean up so that more water can flow through it, and even connecting potentially more water into it. But between the settlement and now, there's been a number of different tie-ins from other properties. Thus, the volume of water has increased while this particular settlement was pending. And the city intends to, but has not filed yet, a motion for summary judgment. So I just wanted to alert the commission that this particular storm drainage system is currently subject to litigation based on its legality and the fact that it constitutes essentially an eminent domain taking, de facto.
Have you, Attorney Barton, have you, and I would imagine that you're dealing with the city law department?
Correct, with
regarding this?
Solicitor Slagle, correct.
All right.
I'm about the fourth attorney on this case, but I'm fairly up to speed on the issues.
All right. We obviously, I can speak for myself. I'm unaware of the current litigation pending on this particular lawsuit, where we have before us a notice of intent. The city law department represents the city and has not, as far as I'm aware, has not communicated any or forwarded any information regarding that to the commission. Mr. Thomas can speak to that, whether, we've been in receipt of anything from the city law department. We will proceed, and we'll invite you back at our next hearing. There will be a representative here from the city to speak on behalf of this project. We're just here, the extrajudicial proceedings that are going on are beyond the scope of this commission, as you are probably aware, and will act in accordance with the rules and regulations of the Conservation Commission and the Wetlands Protection Act. If obviously you have objections to what happens here, as you are aware, there's an appeals process and whatnot, and there's a course of proceeding and procedure that must be followed. And I'm sure you, on behalf of Mr. Matthews, will evaluate what is being done here and any orders that may issue, and take appropriate action in the best interests of your client. And I would invite you to come back and make your concerns known at the next hearing, because as I said, there should be a representative here from the city. I normally don't take comments when all parties are not present.
I'm here essentially to flag the issue, and if anything, I have a copy of the docket sheet, which indicates pretty much just what's happening with the litigation. I did not know if Mr. Slagle was going to appear here. I just wanted to bring it to the council's attention that this is going on the side relative to this particular drainage system. And I thank you very much for taking me on the record. Does this commission meet monthly, bi-weekly?
Our next meeting is in 2 weeks. We meet on the 2nd and 4th Wednesdays of every month.
Yeah, I am not going to be available for approximately 6 weeks. I'm undergoing right hip replacement surgery this Monday. Therefore, I may be looking for a further postponement of this particular hearing, unless Mr. Matthews wants somebody else to stand in for me. Just for the record, that's my situation. But I don't know if there's anybody else. I mean, of course, Mr. Garner was aware of this litigation and these issues, but I am actually the counsel for Mr. Matthews in the litigation, so.
All right. Okay, thank you.
You're welcome.
What I'd like to do before this becomes just an open hearing, well, it is a public hearing, but as I said, I don't like to take public comments unless all parties are present, especially the proponent in this particular matter. What I would like to do is entertain a motion to continue. Craig, did Mr. Cohen indicate a date that he will be back? Will he be back for the second or the fourth Wednesday?
Yes, he indicated that he would be back at our at our next meeting on August 24th.
All right, and perhaps it may be prudent to communicate to him that there's collateral legal proceedings perhaps concerning this matter, that may or may not have impacts with respect to this particular project, and perhaps to discuss it with the law department in advance of coming here on that evening. Do I have a motion to continue?
Motion to continue?
Second?
Second.
By Commissioner Varnum. All in favor?
Aye.
Aye.
Any opposed? The ayes have it. Okay, that will be continued to the 25th, I believe?
24th.
24th? I need to go back to math school. All right, thank you.
If I'm not available on that date, should I file a further motion to continue?
What I would suggest, Attorney Barton, is that you either have a representative from your office or that Mr. Matthews have a representative. The public hearing will continue. It's you've been, or Mr. Matthews has been given notice, but whether or not anyone appears on his behalf is not relevant to the proceeding and going forward with the proceeding. Okay. Generally, if the proponent agrees, that's up to them. But, you know, whether they want to proceed, it's the proponent generally controls the calendar, and we're constrained by the Wetlands Protection Act. Once a hearing has opened, we have to act within a certain period of time.
Period's correct.
Okay.
I've done a quick study on that particular act.
This isn't an adversarial proceeding where there's two parties. It's just really one party. Okay.
Okay, I apologize.
No,
I'm learning as I go, and I am more
that's
used
fine.
to adversarial proceedings.
It's fine. Good luck with you.
Thank you very much. My partner, Attorney Robert Wyman, just so the name may be appearing.
Moving on. Moving on, the next order on the item is a public hearing on an update to the commission rules and regulations, which was continued from the prior meeting. You have in your packets, and I believe it was emailed out today, or yesterday, or the day, emailed this week, the draft, or the current draft with comments from the law department that were included in the most recent draft. I would like to, I'd like to open the, or continue the public hearing with a couple of comments. The first being that we will discuss the draft rules and regulations with the purpose of adopting these as part of the rules and regulations of the Conservation Commission. We will discuss them forthwith tonight. However, we will not close or adopt the rules or regulations tonight. This will be continued as need be to the next hearing date or the next meeting date, and any further meeting dates thereafter as are required. The main reason it will be continued, one is to invite the public, if they so choose, to obtain a copy of these draft rules and regulations. Craig, are these also posted online?
No, it's most of,
Can you tell us then how people would be able to get a copy of these, and how residents of the city would be able to get a copy of these to, or other interested parties in order to comment
yes.
on them?
Any resident or other interested party may request the draft document from me here at the city. My email is available online on the city website for the Conservation Commission, or they may stop in at any time to the Division of Development Services and obtain a copy.
And that's in City Hall?
Yes, City
That's
Hall.
room 51?
51 and 55.
Okay. The second item that I would like to cover is, with respect to the draft rules and regulations that do not involve, and correct me if I'm wrong here, that do not involve the fee changes and the collection of funds and or surety for, under Section 53G, for the acquisition and hiring of third-party experts on behalf of the commission, which must, after we approve and adopt, must also be adopted or approved by vote of the city council. The other rules and regulations that do not involve the collection of money can be adopted after appropriate vote, obviously, by the commission, and will become part of the rules and regulations of the commission without further action from from the commission, from the city council. All right, with that in mind, I would like to open this up for comment. Just to reiterate, since what I said at the last meeting, I would like to thank all the commission members, and particularly our administrator, Craig Thomas, who spent many, many hours, especially the commission members too, who spent many hours of their own time and volunteered their own time to meet, to put this together. This is these are important changes to our rules and regulations. And I believe 4 or 5 meetings were held outside of the normal course of our meetings in order to put these together and to draft these rules and regulations. So I would like to acknowledge and thank all the hard work and effort that went into getting these to this point. We have, that being said, I'm going to open it up at this point in time to the commission. Craig, I'd like to start with you. If you could, one, introduce the comments from Norse Environmental regarding this section, but any other comments that you may have received, or any other comments or concerns that you have with respect to the draft rules and regulations.
To date, the only official feedback that we have received was from Norse Environmental Services, a group that's come before the commission before with a variety of different applications, and they have experience with both wetlands protection laws on the state level and local ordinances in different areas. So for those who don't know what they bring to their comments, the one substantive issue that they raised is in the updated rules and regulations, there's a small sign that is required for a full notice of intent. What's been envisioned and described really is an 8.5 by 11 piece of paper that's weatherproof that lists the site, what type of activity is proposed, and where information may be obtained, both in City Hall and online. Norse had indicated that in place of a sign, it may be prudent to simply require more specific language in the abutter notification form. Currently, most work that is done in the City of Lowell uses a abutter notification that simply references the language in the Wetlands Protection Act, as the local ordinance is silent on abutter notification that says someone, a party wishes to fill, dredge, remove, or alter a resource area under the protection of the commission, which I actually do receive calls frequently for concerned abutters that work is being proposed to either fill a wetland or dredge a river, which is frequently proposed to this commission, at least in the level that would be understood from that outreach. That said, there's nothing that prevents a representative of an applicant or an applicant themselves from writing a clearer abutter notification form and utilizing that at any time. Again, our local ordinance and these rules and regulations are silent as to the content of the abutter notification. It simply needs to require that basic element as specified in the state wetlands protection, which is something is proposed in a resource area and contact information for requesting copies of the forms. It could, well, there are examples that have been used here of clearer language. So at the moment, it is a decision that's made by, again, the applicant or their representative.
All right, and if I may, with the commission, if this perhaps makes sense, what I'd like to do is open this up for comment prior to the commission commenting on the draft rules and regulations. And that way we can get input, since I've already opened it up for a comment made by letter from Norse Environmental, and that way, we can discuss also the comments that are coming in, and if that's okay with the commission. Otherwise, I'll just open it up to the commission. I'm not seeing that there's any disagreement there. If there's anyone here who would like to offer their comments or concerns with respect to the draft regulations, kindly step forward to the podium, speak loudly, and identify yourself, and let your comments be known. Thank you.
Mr. Chairman, members of the Conservation Commission, for the record, my name is Mark Goldman, 58 Oakland Street, Lowell, Mass. And having looked over the rules and regulations as drafted, I'm in complete agreement with them. And however, I do have on the local fee schedule maybe some sort of a change on that. Group 1 has undeveloped land is $25 for the fee structure. To me, that should be more, because you don't know how much land, undeveloped land there will be. If you could increase that to $100, because Group 1 would be single-family home and two-family dwelling. Then you have Group 2 with residences with 3 or more units, mixed-use structures with 2 or fewer, and other things. And I think that undeveloped land should be under that Group 3, because you're going to have, if it's institutional or industrial, and they're looking to develop something in an undeveloped land, and you're charging them, and the fee structure for that is $100. I think that that's only fair. I don't see single-family residences or two-family residences or most of the other things under Group 2 really being charged as little as, have to pay that $25 thing. I think that should be for Group 3. Again, this is just my opinion. So that would be the only change that I would make under the fee structure. To me, that makes some more sense than the $25 that you have listed. Thank you very much.
Thank you, Mr. Golden. If you could, I'd like to make a comment back to you, if I may, perhaps by way of just explaining the thought process behind the fee for that, and this is only for a request for determination of applicability, which is just it's an application to the commission as to whether or not there are any resources that are jurisdictional to the commission. It's not, for instance, if it were an RDA for the and this was undeveloped land that involved more than 3 lots or was a multiple lot instance, and you're probably concerned with the fact that it may be, for a future development of numerous lots and roadway. That wouldn't necessarily fall under this undeveloped land fee structure, okay? That would, and typically, when we do see large tracts like that, it's only small portions of it or some portion of it that is jurisdictional, and the rest of it is not. There are other fees associated with development that may come in front of the planning board or the zoning board, or changes with respect to that, permitting fees and whatnot. This isn't a notice of intent filing in the fees associated with the notice of intent to actually do the work. This is just a fee associated with a request for determination of applicability.
If, and I understand that, Mr. Chairman, but if that could be spelled out in the document, in the regulations and rules, I think that people would maybe have a good understanding of that. So maybe I'll throw that out to you.
All right.
Thank you.
Thank you very much. Is there anyone else who would like to offer their comments or concerns with respect to the draft rules and regulations as currently proposed? All right, Chair notes that that there's no one else here to speak with respect to that. And in that light, I would like to open it up now to the commission members for their own comments or concerns, modifications, requests, or changes to the draft rules. I'm going to put you on the hot seat, Bill. Commissioner Lovely?
I was at 3 of the meetings, I believe, so I have no comments at this time. I'm happy with the current form of the rules and regulations, and I guess we'll just wait and, I guess agree when we make a motion to continue to offer my vote of support for that.
All right. Commissioner Chalupka?
I also, made all of my comments at the meetings. I just, in regard to the email from North Environmental Services, I'm all for making the notification to abutters more clear, but I would prefer if we could keep the sign as well, or add the sign, I should say, whether or not we improve the notification to abutters. I think the sign is an important way to reach people who are not abutters, who might just be driving by. That's all.
Commissioner Varnum?
I think this updating of the rules and regulations was long overdue. We were looking at some rules from the 1980s when we began. So there were several drafts before this last one. And I'd like to commend Craig Thomas for doing such a wonderful job of pulling everything together and including our comments and suggesting changes to come up with this final form. I'd also agree with Ms. Chalupka that I like the suggested wetland protection letter, notification letter that Norse Environmental sent along, but I'd also like to still see a sign on the sites, because there are some interested parties that aren't necessarily abutters.
Commissioner Mellon?
Yeah, I agree with the previous comments on the recommended sign being posted, but also, the notification of the abutters as to what the proposed project is going to involve.
Commissioner Lynch?
I agree too. I think it's a good idea to inform the abutters beforehand about what's going on in the project, because sometimes, even though they get the notice, they might not know exactly what's going on, and they might not drive by a sign either. I think the sign is a good idea, though, because I know a lot of people will stop and read it to make sure that they understand what's going on too. So I think having both of these would be really helpful.
All right, thank you. I think the on-site sign as Commissioner Chalupka has indicated should remain. It's not, and we've had issues in the past where people did not get notification, maybe they're away or whatnot, and they don't sign for the green card, or a spouse signs for it, or someone else living at the residence, a minor child signs for it, and they don't actually give it to the landowner or the person who's really who would be otherwise interested. So having the notification on the site, I think, is a great idea, and it should remain. With that in mind, however, what I would like to propose is some slight language change to that, and that would be, I'll start from the back and move forward. That would be section 7, Roman numeral letter 4, as proposed in this particular draft. It said sign shall be waterproof and created to be legible for several weeks. What I would like to propose is a change of that to read, said sign shall be waterproof and maintained to be legible for a time period specified in the section Roman numeral 5 below. And so instead of it just being for several weeks, it shall be maintained to be legible for the time period specified in section 5 or in subsection 5, which is after all appeals periods have expired. What I would like to also propose is in subsection 5, or Roman numeral, this would be section 7, subsection 5, as the draft language is, said sign shall contain no additional advertisement or words other than that which is intended to meet the requirements herein. No changes to that. Then it continues, the sign will remain in place until the end of the appeal period for an order of conditions. What I would like to do is, or what I would like to propose is to change that to the sign will remain in place until all appeal periods of the public hearing have expired. And what that means is the sign shall stay whether or not an order issues or not. The potential is that the order could be denied, and there's still appeal period that remains with respect to that. So it covers those eventualities. I only have one other proposed change, and it would be with respect to subsection 4 or section 4. Let me see if I can get this right. Yes, section 4, and that deals with the situation where the applicant is a non-human entity. Subsection 4 as proposed currently reads, if the applicant is a realty trust or limited liability company, LLC, the representative shall provide evidence of the legal existence of the entity and contact information for a trustee or a member. I think that's a little, and that's the end of it. I think that's a little limiting in its language. It should perhaps, or we should consider broadening the language of that section 4 to include corporations, partnerships, even DBAs. And what I would propose would be language to this effect: if the applicant is a corporation, LLC, partnership, trust, realty trust, or other limited liability entity, then the applicant shall provide evidence suitable to the Conservation Commission of the current legal existence of the entity, together with contact information for a principal, president, trustee, agent, or member, as the case may be. I'm trying to read my handwriting here. As the case may be, who has full authority to act on behalf of the entity before the Conservation Commission. And then finally end it with, in the event that said entity or its representative is a non-resident of the Commonwealth of Massachusetts, that contact information shall also be provided for a resident agent. What that means is that we, as a commission, are not required to go beyond our borders in order to contact a representative for the company or their appropriate representative who will appear before us. But it also, I think it broadens the language to include other sorts of limited liability or other sorts of non-natural entities that are created either by statute or by common law. I don't have any other comments. I think this is I agree with Commissioner Varnum. This was long overdue. for these changes, and I'm thrilled that we're finally addressing it and we're finally at this stage. I don't know how what I would like to do, or at least what I'd like to do now is, I guess, is open up discussion amongst the commission as to whether or not the changes and to the proposed language, and I'd like to I would like to identify and address the changes, I guess, one by one, and I'll characterize them. One is Mr. Goldman's requested change to consider whether or not we should remove the undeveloped land or increase the fee for undeveloped land from Group 1 into either Group 2 or Group 3. And I'd like to open that up now to the commission to see whether or not we would like to adopt that or consider that for a change. To the draft. Commissioner Lovely?
I'd recommend that we leave it as is in light of the context of how that fee was developed. It is for a request for determination of applicability, not for notice of intent or any other request of the applicant. And further to your point, Craig, that in many cases, it's only a certain portion or a small portion of the undeveloped land that's subject to the Wetlands Protection Act. And in light of that, I think the $25 fee, and for the undeveloped land is appropriate.
All right, excuse me. Actually, maybe I can make this a lot simpler. If I could entertain just a motion to open it up for discussion in order to either a motion to change the fee for undeveloped land or remove the undeveloped land RDA fee structure from Group 1 into Group 2 or Group 3, or to keep it as is. Since you opened it up, Commissioner Lovely, perhaps you can make a motion, to keep it as is, or to move it, and then we can get a second open it for discussion, and so we're not discussing this ad nauseum tonight.
I offer a motion to leave the current fee structure for undeveloped land as is.
Okay, do I have a second on that?
Second.
All right, by Commissioner Lynch. Is there any discussion from the commission with respect to the motion to keep it there?
I think one of the rationales for having a low fee on this particular item was to get people to come in and start the process of filing. We've had cases over the years of people just doing projects without consulting with conservation, and a high fee might encourage them to continue in that vein, but a lower fee might encourage them to talk with conservation and go through the process.
Yeah, I agree. Any further discussion? All right.
I just have
Commissioner
one
Chalupa?
comment, sorry. I agree with Mr. Goldman that it, with the spirit of his comment that undeveloped land should be more difficult to develop, especially when it is part of a wetland, but I, am persuaded by Commissioner Varnum's idea that what we really need to do is get people to come before the commission when they are thinking about doing something. So I, feel like they would be more likely to with a $25 fee. That's all.
Okay, since no further discussion, so with respect to undeveloped land, the motion is to leave it in Group 1 under the proposed or the draft fee structure at $25 for request for determination of applicability. Do I, all in favor?
Aye.
Opposed? The ayes have it. Okay, so there will be no change to that. I'd like to take the Norse environmental comment, which I'll characterize as the Norse environmental comment. I suppose we can take it in two parts, or actually three parts. The first being, and it's the latter part of their comment, that the abutter notification that's mailed out also include the abutter notification form as part of the abutter notification. What I would like to do is, I suppose we would add that, assuming, well, let me open that up for discussion. If I could entertain a motion, just open it up for discussion to include the abutter notification form as part of the abutter notification. And if I could entertain a motion either to include that or not to include it, and that way we can open it up for discussion.
I move to continue including the abutter notification form. Wait, hold on, let me pause here. Do you mean the one that we already have?
No, this would be in addition
Okay.
to
Yes.
the language we've already proposed in the draft.
Okay, so let me amend that. I move to add to the existing abutter notification form.
All right, do I have a second?
Second.
All right, now, open it up for discussion. I guess I'm a little bit mixed. Anytime more information goes out, I suppose it's always a good thing, but the current notification form that goes out to abutters now is, and I suppose Craig could comment on this most because he hears the comments back, is somewhat purposely vague and all-inclusive. And I suppose, for me, I would rather leave it like that because it invites people to call. It invites people to contact the Conservation Commission and say, you know, what's going on? You know, what are they doing? What are they proposing to do? I guess the flip side to that is as a part of the abutter notification that more particular and detailed information is provided, it may negate or obviate some of those calls into the commission. And there may be other reasons too, but so you know, with those comments in mind, I'd like to open it up for comments. Commissioner Varnum?
I think more information, the better, without it becoming burdensome on the administrator or whoever is filing the form. But for instance, if an abutter were to get a vague form on a Friday afternoon and couldn't find out until Monday morning what was going on, that could cause quite a problem for that particular person. So I think a little more information is a good thing.
Commissioner Lovely?
With this, Craig, I'm thinking, looking at the form that's in front of me, would we need to put additional language in our rules and regulations, you know, to specify what additional information in particular we'd be looking for? You know, to Chris's point earlier that, you know, it's intentionally vague, the notification, to be all-inclusive. So if we want to counter that with more specific information, what exactly are we looking to include in the notice?
I think that there are two ways to view it. Excuse me. One would be to spell out in the rules and regulations the specific language of what the abutter notification will contain and potentially what it may not contain. The other way to view this is So that is done with another portion of this where we talk about signing off on submission of materials to the DEP. The second way to do it would be to include the approved form, in the rules and regulations and simply reference it within one of the articles as outlined to say a butter notification form as included shall be used.
All right, thank you.
Commissioner Chaluka?
I agree that too much information could be burdensome. I would be happy with having the form just include the sentence in this example that says what the proposed project includes, because I think that's the thing that neighbors would be most curious about. I mean, you can probably comment, like, when they call you to ask about what's going on, they just want to know what the project is, right?
Yes, the overwhelming majority of the calls I get are concerned because, again, they refer to the language of dredge, fill, remove, alter, and without any additional information. Again, that is not always the case. And in your packet for this week, there were examples of butter notification forms that were more substantial than that. But including specific language about what the applicant is proposing may the specific language may ease the confusion of residents who only have a quick moment to try and figure out what this form is telling them about their neighborhood.
Thank you. Yeah, so I mean, at a minimum, if we're adding anything, I would like to see the one sentence saying what the project is. That's all.
Commissioner Mellon?
The abutter notification is provided by the assessor's office?
The list of interested parties is provided by the assessor's office, but the actual form is provided by the applicant or their representative. Again, there's very minimal reference to what it needs to contain in the Wetlands Protection Act. The local ordinance is entirely silent on what it may or may not need to contain, but that could be addressed through the rules and regulations.
Well, I agree that a very brief description of the project, not a scope of work, but a very brief description of the project so that the abutters know what's going to be happening in their neighborhood would be valuable to them.
Commissioner Lynch?
I agree with the commissioner's statements, and I think that the example that was provided by Norse Environmental was a good example of perhaps what we should adopt for our butter notices. It doesn't give too much information as far as the project, but it gives just enough for maybe less calls to the office about what's going on, things like that. So I think it would be a good idea to look at this more and maybe take from this what we need and adopt it.
One other comment on this. I tend to agree that we could adopt, we could include language into the draft to also include, along with the notification, this additional abutter notification to provide more particular information about the project. But I don't see it as a panacea to. It would almost invite more questions. I think when you provide more information, which is a good thing, but it may also invite more questions to explain what it is that this notification is all about, and then what the project is about. I suppose I would like to make one comment. And it's at the very bottom where the applicant is indicating that they will provide copies for a fee. I would like to propose language that, you know, one, the city, I do not believe, charges a fee to provide copies, or do they?
So that's actually fees that are charged by Norse
Yes,
Environmental.
no, I understand that.
The city is required to charge for copies, both regular 8.5 by 11 and for larger map prints. For 8.5 by 11 photocopies or computer printouts, the fee is exceedingly nominal, something on the order of 2 cents a page, I believe.
Okay.
For the only fees that are typically of concern when requesting documents from the commission are the size D or the full-size map copies, which run from between $10 and $20 each.
And can those be provided electronically?
Yes, any documents that we have electronically are a public record and can be provided to anyone at their request.
Okay. What I would like to do, and I don't want to step on anyone's toes, but I don't particularly like the language at the bottom of the notification. What I would like to do is at least as far as the abutter notification form that goes out, if the applicant chooses to charge a fee per page, that the fees shall not exceed what the city would otherwise charge for the same documents. All right. And that would have to be spelled out to the applicant also. They may include their, you know, two cents per page, or, you know, or whatnot, but I think $1 per page in copying fees is a bit excessive, considering that some of the notice of intents that we get in can exceed 100 pages in length. So I think that's a bit excessive. I suppose in that vein, all we'd need to do, because I'm getting a consensus from the commission that we would like to include, in addition to the signage, also this additional abutter notification form. I suppose what we could do as part of the draft would be to draw up in a form abutter notification to include it with the draft, and then make reference to it as a part of the rules and regulation with respect to notifying abutters, that in addition to the notice as required by the CMR and by the statute, that the applicant shall also include the abutter notification form as, you know, as attached to the rules and regulations as form, you know, whatever, form 1, form whatever we choose to name it. And you'd be able to include that language in the next, and draw up an appropriate form.
Yeah, that could be done rather quickly.
Okay. Now, I'd like to take up the first part of Norse Environmental's comments, and that would be to negate the on-site sign and notice as outlined in section, this would be section 7, subsection, section 7. I think I'm getting a consensus. Well, actually, why don't I open that up by motion? If someone would entertain a motion to either negate that language, that there shall be no on-site signage, or to keep it as proposed, or to a motion to, and this is where I wanted to bring in my comments and propose language to make changes to the draft language in accordance with the comments that the chair made previously.
I move to keep the regulation to have a sign on the site and incorporate the comments of the chair.
All right, do I have a second on that?
Second.
All right, any discussion on that motion? No. All right, all in favor? Opposed? The ayes have it. And Craig, if you need the language on that, I suppose you have it in the record, but if you need the language, I can provide that. I have it written down here, so.
Yeah, after the meeting will be helpful.
Now, lastly, with respect to section 4, which deals with limited liability, limited liability entities, I'll entertain a motion either to keep the language as proposed in the draft or to modify the language, or to change it to something else, or to modify the language as proposed by the chair, or to change it to something else. So if someone has a motion on that.
I'll offer a motion to amend the language as suggested by the chair.
Second.
Seconded by Commissioner Chalupka. Open it up for discussion. Is there any discussion on that? No? Okay. All in favor?
Aye.
Opposed? The ayes have it. All right. Craig, I can also give you that language too. And obviously, you'd perhaps want to run that by the law department and for any additions or changes or to make it more complete. And I don't believe there's anyone else, any other changes that are mentioned at this time. I'm assuming that the commission is otherwise satisfied as will be. So the what's going to happen now is I'll entertain a motion to continue so our administrator can include the changes discussed tonight, and this will be continued to the next hearing, and we can discuss both the new changes at that time and continue to discuss the document and any other changes that may come in or suggestions that may come in during the comment period. So the comment period will remain open till the next hearing and to subsequent hearings until such time that we close and formally vote on this. So do I have a motion to continue at this time?
I make a motion to continue to the next meeting.
All right, seconded
Second.
by Commissioner Chalupka. Any discussion? All in favor signify by aye.
Aye.
Any opposed? The ayes have it. Okay, thank you. Okay, moving on. All right, moving on. This is notice of intent from Adam Back, doing business as the City of Lowell. The project location is 341.1, 341.2, and 369.1 Jackson Street, and a portion of Canal Street. This is concerning DEP file number 206-0678, and it's construction of a parking lot and associated drainage infrastructure in the 100-foot buffer zone to an inland bank and to it the Lower Pawtucket Canal. And if I could have you identify yourself for the record.
Sure. My name is Charles Ware. I'm with a company called Meridian Associates. We are the civil engineers on the project. I also have with me this evening Larry Sparrow, who's with Trinity Financial, and they have partnered with the City of Lowell on this project. Mr. Chairman, if I may, I have some presentation boards. If I could inquire, is the best place to set that up so we can see it?
Craig, if you could help out Mr. Ware.
Typically, what's easiest is to put it here, and we have a wireless microphone that we can find to assist you. So if you set up your stand here.
Do you have additional copies of these maps that you're showing us?
The map that I'm showing you is actually the plan that was submitted to you, with the exception that we've colored it.
Okay, because I just
welcome
want
to
you to
keep-
understand that that has to stay.
That's fine.
Okay.
That's fine. The first point of business is to provide you with the green cards of the public notification. This project is part of a much larger project, the Hamilton Canal District. The drainage calculations, just to give a brief overview, the drainage calculations and the stormwater management that has been submitted with this date back to 2008. And the stormwater calculations were provided to MEPA, and they went through a very intensive peer review by both DEP and I assume by this commission at that time, as the draft EIR and final EIR were submitted both to, it was submitted to any number of agencies, but it was submitted to this commission along with to DEP, and DEP weighed in on that. The drainage calculations on this are global for the entire Hamilton Canal site. They were reviewed under MEPA, and then they were reviewed again under the notice of intents that were filed for Canal Street, which is this section of is Canal Street, which was an order of conditions that was approved previously, and then diagonally across from this site is the Appleton Mills project, and it was also the same drainage calculations on that. We have updated the stormwater management because there has been updates in the language of the stormwater management requirements. So we've updated that language to fit in with the current regs. This site, as you know, is just off of Jackson Street. As you come, there's a temporary bridge in this location. You come over Jackson Street, and then on the left is it's vacant now, but it's paved, mostly paved. Pavement is not in great condition, and the site is surrounded by the Pentucket Canal on this side and the Hamilton Canal on that side. The site is owned by the city. The area around there is space between the actual canal itself and the limit of the lots, and that land is owned by the National Park Service. Canal Street is owned by the city, as well as this strip next to the 110 Canal property. The intention is to create a 124 space parking lot. The intention of the construction would be to pulverize the pavement, which is in place now, and then supplement that with gravel, and then to repave that. shaping it into a bowl shape so that all the drainage drains to the center of the lot to there's a proposed catch basin here, and a proposed catch basin here, and a third proposed catch basin there. Those 3 catch basins will then direct runoff into the utilities that were recently installed as part of the Canal Street drainage system, which include the storm scepter, which provides most of the treatment. So the treatment on this is the deep sump catch basins and the storm scepters. I can run through very quickly. As I mentioned, the drainage calculations have already been through a pretty rigorous peer review by DEP during the MEPA process. I can run through the stormwater handbook requirements, the 10 standards which need to be met. The first standard is that no new conveyances of untreated stormwater will be directed into the waters of the Commonwealth. As I just mentioned, the installation of the catch basins as well as the storm scepter provide for a treatment rate greater than the 80% required, so that that water is treated. The second is attenuation. We've submitted the hydrologic calculations for the site that show that overall that there's no increase in any of the rates of runoff into the canals. Again, that's the report that went through the MEPA review. Infiltration on the site, there is no infiltration, and the reason for that is because there's contamination on the site. Again, that was peer reviewed as part of the environmental impact report that was done for MEPA. The DEP agreed that infiltration was not practical on this site because of the contamination that's on the site. Infiltration would only lead to the possibility of further contamination of groundwater in the area. So the idea is to prohibit infiltration by placing impervious surfaces over the site and get away from kicking contaminants loose that could then contribute to the groundwater. I can get into more details on that if you have questions, but water quality, it's really number 4, the same issue that I just brought up, which was deep sump catch basins and storm scepters provide for the 80% removal rates. The site in and of itself, the site on standard number 5, which is sites with higher potential pollutant loads. Because the site was treated, Hamilton Canal was treated as one district, it is considered to be a LUPL because there'll be at least 1,000 trips per day created by the total build-out. This parking lot in and of itself would not be a LUPL, but because it's part of the larger project, it is considered a LUPL, and as such, we have to provide for a higher intensity treatment. In other words, under a non-LUPL, you treat for 1/2 inch of runoff. For a LUPL, which this has been treated as, you treat for 1 inch of runoff. So you treat for a higher amount. And the storm scepters was sized for that higher intensity. Standard 6 does not apply. That applies to critical areas. In this area, we're not in the vicinity of any critical areas. Standard number 7 regards redevelopment. This certainly does define as a redevelopment site. However, we do meet all of the other standards with the exception of standard number 3, which I mentioned earlier, which is the infiltration. So we have met the standards to the maximum extent practical. Standard number 8, we've provided for construction period erosion control and the operation and maintenance, which has been filed with the notice of intent. Standard number 9 involves the long-term maintenance of the BMPs which have been provided, and that provides for the cleaning of the catch basins as well as the storm scepter. And then number 10 is the illicit discharge statement, which will be done prior to the completion of the project. And if there's any questions on that, I'll entertain that. And we also received a letter, a memorandum from from Craig, from Mr. Thomas, and I don't know if you want me to go through that or if you'd rather just bring that out during questions.
I'm sorry, you can comment on that.
Okay.
Because we're going to be discussing it anyway, so you can.
Yeah,
while
that's
you're
fine.
here.
The first comment had to do with the determination of floodplain and, or land, bordering land subject to flooding. I provided a letter on that earlier today to clarify that. The site does not flood. It didn't flood in the Mother's Day storm historically. There hasn't been flooding of the site. In fact, the area that FEMA shows as being an area where it's supposed to flood is actually the high part of the property. I believe the FEMA maps in this area, it references a profile, a FEMA profile. There is no profile of the flooding, that quote-unquote flooding that would occur in these canals. And as I'm sure you know, the flooding which occurs in the Merrimack River these canals are cut off from that with a floodgate. So this doesn't occur, and the flooding does not occur down here. If you look at the maps, what's been done is, because there is not a detailed study of the canal area, they simply just draw a line on an aerial map and declare that to be quote-unquote a flood zone. Those maps are not terribly accurate. Based upon the historic evidence, there is no flooding of this site, and as such, the canal walls, in my opinion, are the limit of the land subject to flooding, and we've defined that as such. Yeah, some of these things are very basic, very straight ahead. In our operation and maintenance, there's a request that we clarify which structures we show our filtration. We're proposing filtration nets inside the catch basins, and we can certainly provide that detail. I was actually unable to find this next one, other than there's reference to rain gardens. There's no rain gardens proposed during this phase. There are rain gardens that were part of the Appleton Mills project, and there will be rain gardens that are proposed in future phases. But at this time, there are no rain gardens proposed in this phase. In fact, this parking lot is temporary, which I probably should have pointed out earlier. In the long term, there'll be 2 buildings that will be constructed here, and then access to a park out and back. But for now, this parking lot is a temporary structure, and to provide parking until future phases, because there is a parking garage going in future phases of this project. So this is to provide parking for the short term for the buildings that are going to be going in this area, and until such time as the parking garage, which is actually on the other side of the Lower Pentucket Canal,
If
is
you could
constructed.
explain briefly what is meant by a rain garden?
Rain gardens are they're very similar to they're like small detention basins. There are actually 3 of them over in the Appleton Mills. When you see them, they look like just small concave-shaped landscape islands. And the idea behind those is that you plant species in there that will give you uptake in and treatment of the stormwater that runs into them. The ones that we designed have an underdrain system underneath them because of the contamination I mentioned earlier. Oftentimes, they're like infiltration basins with vegetation above. In this case, what we did is we put a pipe collecting underneath with an impervious barrier, so that as the water ran through and was treated in the soil and in the vegetative matrix in that rain garden, it then got captured by that pipe and carried off into the drainage system. Again, that was on an earlier phase. We're not proposing any on this phase, but they're essentially small vegetated treatment structures, landscape structures. Sure. Exactly. That's the intention. They're more applicable, although DEP certainly wanted us to utilize them, and that was something that came out during the MEPA process when we got the EIR process. They're actually more applicable to more suburban type development, residential developments, where you can place, if you put in a single family home, you can put a rain garden to capture the roof runoff and the driveway, things of that, and you scatter. They're very small, so the idea is to scatter many of them around. If you had an 8-unit or an 8-home subdivision, you'd scatter several of these around the site instead of doing one big tent. And then they're actually kind of hidden. If you went out to the, I should have brought this up during the site walk at the Appleton Mills, but when you see these at Appleton Mills, when you walk by them, you think they're just landscaped islands. You don't realize what they are, is they're actually rain gardens. They look like landscaped islands. So, and that's the idea, is that they fit into the landscape. They're not these big, giant detention basins. They're these small pockets that fit into the landscape, and you don't even realize that the treatment is there. So. There is the request that we show snow storage, which we can certainly add to the plan. The city does own this property right to the back of the site, which is intended to become a park. In the short term, that certainly is an ideal place where snow storage could occur. And we can add that to the plans and confirm with the city that that's what their intention is. The Board of Health mentioned, and I think this probably goes more to the 110 Canal Street, but mentioned disposal dumpsters. For a parking lot, we're not proposing any trash or dumpsters for this parking lot. There certainly will be, and we'll talk about that when we get to 110. There certainly will be, the users of 110 will have solid waste, but we don't anticipate that there'll be any solid waste coming from the parking lot. There was Larry can speak. Do you want to speak to the issue of the curbing? There's a suggestion that curbing be put around the edge of this, and I know that having spoken with Larry Sparrow with Trinity, they would prefer not to do that. The drainage from the site does drain back into the catch basin, so there's no real need for the curbing for drainage purposes. What Mr. Thomas had suggested was that the curbing may keep cars from driving out into that area. Larry would like to propose a middle ground, that we not do the curbing, but if it became a problem where cars were driving out, that the curbing could be installed at a later time. But I think that where it's a temporary parking lot, the preference would be not to put that curbing in. Sure, go ahead. Yeah, that's a fair comment. What do you think, Larry? Got any ideas about how that would? Do you want to?
Yeah, I'm not, I think I understand.
If you could identify yourself for the record.
Sure, I'm Larry Sparrow with Trinity Financial. We will be building this lot for the city. And it just, I mean, I see curbs like that, about 2 minutes curb, getting hit by snow plows, making a mess. They end up an eyesore in some respects unless they're very well maintained. And when we're bringing all our drainage internal to it, there's a bit of land there, and then the Park Service will have fencing up there. The city's going to be building a park out there. And as a temporary measure, I didn't see the need of the expense to add curbing.
There was a couple more. There was a suggestion here that the site be prohibited from using salt and chemicals for ice. I don't see any issues with that. That's pretty much standard. And then there was a suggestion as well that perhaps that we build into this order of conditions the ultimate removal of this pavement. I don't really think that's necessary. I think the this parking lot will remain here until the future buildings go in. And when those buildings go in, we'll have to pull new water conditions at that point. So I don't think that's necessary. Other than that, I'd be welcome to field any questions you folks might have.
Yeah, I have a bunch, actually.
Sure.
And some of them have been addressed already, and some of them I would like to go into a little bit more detail. I suppose I'll start with the easier ones first. One is, as part of an O&M plan to be submitted for the maintenance of this parking area, I would like to see that any snow removal contractor, as part of their contract, be notified that there are to be no salts to be used on site. For the same reasons, that we did with the pedestrian bridge. It's just where the site is, and the immediate, sand is one thing. It's going to end up in the separators, but the salts get dissolved and are going to be in the canals and in the Merrimack River within a half an hour. So, and that's just where they don't belong. The second comment is related to that, and I think it needs to be addressed in more detail tonight, and in more detail on your map as to where snow storage is going to be for this site, because I feel that two things are going to happen. One is that not only will the snow from this particular area be stockpiled somewhere nearby, or perhaps towards where it towards the western side, where it indicates Lot 3, but also a lot of the road snow will also be placed there too. So I think we need to develop some sort of plan and develop some sort of system, some sort of method, and some sort of area that's going to be suitable to stockpile snow, one, two, to account for its meltage and drainage back into the system under controlled circumstances, so it's not overtopping any banks, and so it's not enjoying the protections that the catch basins would otherwise serve. Okay, I think it needs to, one, not be infiltrated as you're indicating because of the particulars of the site, but two, it's anytime we're dealing with a parking area of this size, we have to be concerned with that. So I think we need to address that. The third thing, and I would like to ask you first a question. Is this parking area going to be exclusive? Is it going to be gated? Is it exclusive to the residents of this area, or will it also be open to the customers of the work-live spaces that are currently on site and to be built? Will it be open to the public?
Is this on? Yeah. I've met with Chuck Carney a couple of times from the city parking. He's a parking commissioner. And they are proposing to put in gates. We're going to provide the conduit for it, and then they'll put their gating equipment in it. And we're going to add a small fence along the back of the parking lot so not anyone can drive in there. So it will be it's gated. They're looking mostly as monthly. It's mostly being built for the development of 110 Canal, recognizing that in addition to that, it will be open to some of the residents that we've just built at Appleton Mills, if there's space available.
So it'll be controlled by a pass card or some
Correct.
Okay.
Yeah,
Since it's not open to the public, then I suppose it's the second part of my comment, and what I was leading into is the residents will perhaps be more diligent about this, but it's always a problem in large areas like this, and there was a comment or comments from the Board of Public Health that as to the placement of dumpsters, what I'm more concerned with would be, and again, as you may want to consider the placement of several trash receptacles. There's going to be human foot ingress and egress, and hey, they all get the coffee cups and whatnot, and sometimes the car door is opened and they're dumped. And if there's an easy or convenient nearby trash receptacle, it's more apt to be used than not. Again, if the lot is more, and I say this in the vein of the resource area, is because otherwise, as you are aware of the site, it's very flat, it's very open, and especially in the wintertime, with the winds and whatnot, something like that is going to end up in the canals within a very short period of time. The canals are not really protected by any sort of high walls or, any sort of windscreen that's going to keep debris such as that out. So having some sort of a trash receptacle near human ingress and egress points, I think would be beneficial. One, it's going to keep the site up, but two, it's not going to be introducing debris into the canal system.
I can review that with the city. We certainly have trash receptacles along the street. And it's interesting, but studies are being made about a lot of parks are going, no trash receptacles, bring in, bring out. And they're actually finding some parks are much cleaner that way than if you provide trash barrels. So, although I hear your comment.
All right, then
I will just offer that. But I will certainly discuss that with the cities if they want.
I'll gladly defer that to the experts, and if it's been a considered topic, and human nature being what it is, if it's found to be better the other way, then I'll that's fine with me. My main comment, however, though, is we'd all love to be able to predict the future, and I'm sure all of us would have loved to have purchased Apple stock back in 1997 when it was trading at $5 a share, and now it's the world's richest company. Being that as it may, and understanding the uncertainty of the economy, I know what your future proposed plans, or at least an abstract, are for the site. I, for one, however, am not of the mindset to allow the build out of the parking area to be done with the opinion or with the intent that it's to be temporary. If it is to be temporary, and it indeed does turn out to be temporary, that's great. We can draft, or we can make that a condition of the order of condition. I would be of the mindset to keep this order of conditions open, or at least to make a permanent condition on this. One, that the applicant would be to within, and I don't know what your proposed schedule is for the ultimate build out of the site, and perhaps you don't either at this point in time. But it would be to, to the extent that a permanent condition would remain on this, either to require visitation of this site within 2 years or within 3 years, and that if no further development or order of conditions at that point in time is filed prior to a COC issuing on this, then, then the applicant must take steps in order to make this parking area a permanent parking area, and to build it out accordingly. Including curbing and berms as are appropriate. I'm not of, I understand you don't want to build a temporary parking area to withstand, to be a 10-year or a 20-year parking area. If, it's at some point in time it's wasteful and it's economically wasteful. But in the same token, not knowing where you're going to be, 3, 4, 5 years down the road, it would be imprudent for us as a commission to give the green light for a temporary parking area without any sort of safeguard in place to know that, in 3, 4, 5 years, well, this is going to become permanent. Our plans have changed. It's no longer economically suitable or feasible to build the site out as we originally had planned. And we're just going to keep it as is, in which case we're left with a situation where, we have a parking area that was designed to only be there for a couple of years, and some, some concessions were made, and now we're in a situation where this is, the ultimate resting place of this parking lot for its serviceable life. So you have to see it from our standpoint, and from that standpoint, that that we either build it out to be permanent, or we leave it open, or we make permanent conditions that that it will be revisited within X period of time, to discuss at that point in time whether or not this is to become a permanent build out, or you're going to proceed with a new project.
This works? Yeah. So I understand the concern, and we really don't know. Is it going to be 3 years, 5 years, 8 years? We're proposing 2 major buildings on that site, and we got a few buildings to build before those. They won't be the last ones built, but they're not the next few either. So I don't think 2 years is too soon, but in 4 or 5 years, this will be a revenue generator for the city. They will be collecting, and I would think the city, and I'm sure we'll be participating in a review if it looks like it needs more permanence. It's certainly appropriate. We're not going to want an eyesore there either. I mean, we get major development there, so if it seems to be taken on a more temporary permanence, we all have faith that it will eventually get built out, but if it turns into 10, 12, 15 years, it behooves us all, I think, to make that far from being any kind of eyesore or getting beat up, and it would make sense to keep it in top shape. That's my sense. I'm speaking for Adam, and you know what I mean? It's inappropriate for me to really speak for the city. It is their lot, and we're doing this first round for them, for you. So it seems reasonable. I would think it seems reasonable from my perspective that this can be opened up for review at some point in the future for those things like curbing and making it look a little more permanent.
All right. I don't have any further comments, so I'm going to...
If I could just speak very briefly to that as well, is just to give this commission some confidence in that the stormwater pieces of this, if this parking lot became a permanent fixture, the stormwater pieces meet the regulations as if it was a permit. So there's no shortcomings in the stormwater piece. Certainly the discussion about curbing and berms and things like that, certainly it's not a permanent, but all of the, just to let you know that all the drainage fixtures in place that we'll be tying to would serve this site as a permanent parking lot, should it come to that.
We don't want a Rourke Bridge.
No, I understand.
I wasn't going to mention that, but that was in the back of my mind. Commissioner Lovely.
Just had a question with regard to standard number 1, where it says stormwater from the proposed catch basins will connect to the existing drainage system in the Canal Street. You were pointing out there are 3, I guess, catch basins on site.
Yes.
Can you tell me what the ultimate outfall is when it connects to the city's stormwater system?
I'll draw right on it. As I mentioned, there's a catch basin here, here, and here. The ultimate outfall, it was actually just recently installed as part of the Canal Street. There's a drain line which comes up. There's a storm scepter, which is a treatment facility right here. And there's actually a drain line that comes up and is stubbed right there. The intention is that these will connect, and actually this one comes up, is to connect into that existing drainage, which is in Canal Street. And this was actually constructed for the purpose of these being, constructed on and be mostly impervious surface. So whether they're the building or a parking lot, it's been sized appropriately.
And is that a dedicated stormwater line that goes directly into some outfall like the canal or the Merrimack River, or does it go to the water treatment plant?
No, this is stormwater, and it goes into the lower Pentucket. The outfall is the lower Pentucket Canal.
All right. That's what
To that canal.
and those load calculations don't show any net increase load over the current condition.
That's correct, because right now the entire area was previously, there was no treatment at all. So this actually, if you took what was there when it was an operating mill versus what it will be when this is done, the removal rates are 80%. The removal rates, the removal rate today is 0 for this area. There's a paved parking area which just runs, surface into this. So there's a significant reduction in the total suspended solids. And also looking at the site as the whole Hamilton Canal District as a whole, and the rate of runoff, there's actually a slight reduction in the rate of runoff from what was there previously as mill facilities and what will be when this is built out. So hopefully that answers your question.
It does. Thank you.
Commissioner Chalupka? Commissioner Varnum?
No questions.
Commissioner Mellon?
The only comment I have is administrative.
Sure.
On these drawings, you show a locust map,
Yep.
and you have Thorndike Street, where it should be Dutton Street.
Okay, I stand corrected. I know it changes right in the middle
Thorndike
there.
Street changes at the...
Right at the Lord overpass.
At
Yep.
the, no, not at the Lord overpass, at the canal.
Corner.
Right at the
Ed
canal.
Fletcher.
Okay, we'll fix that.
Other than that, thank you for your explanation.
Commissioner Lynch?
I think the commission has already addressed the concerns I had, so no comments.
Is there anyone here who would like to offer their comments or concerns regarding this project? If you kindly identify yourself for the record.
Thank you very much, Mr. Chairman. Members of the Conservation Commission, for the record, my name is Mark Goldman, 58 Oakland Street, Lowell, Mass. And I wish to be recorded in favor of this project. I have attended various vision sessions that took place regarding this entire Hamilton Canal District development, and including reading the master plan. I am very confident that all the buildings that they're proposing to build will be built. It is an overall 10-year plan. It may be an additional year or two, but they would hope that it's done before the 10 years is up. But it is a long process. It is a long view of what is going to happen in that whole area. And I urge that whatever conditions you propose will be all right, except that I honestly do not believe that this parking lot is going to be a permanent parking lot. So I don't see the need for any berms or anything to be put in there. Thank you very much.
Thank you, Mr. Goldman. All right, there's a couple things, and a couple ways to proceed. One, there's a jurisdictional matter that was raised by Mr. Thomas, and there's a letter from Mr. Ware in our packet, who is a certified engineer, and he's certified the jurisdictional issue, just to outline it as, as raised in the memo. Perhaps it was glanced over, but we have to act on it one way or another. Is the firm maps show portions of the site to be within the 100-year floodplain, but yet we haven't really discussed that all that much tonight. The letter from Meridian Associates dated August 10th, 2011 contains a certification, and correct me if I'm wrong, if I'm mischaracterizing it, that it's the opinion of the engineer that the floodplain is contained within the canalways and does not come up onto the site as shown by the firm map. There's two ways that can be dealt with. One is, I believe, through, what do they call it, a letter of map change through DEP, or through, not DEP, through, it ultimately goes back to the Army Corps, doesn't it?
It goes to FEMA.
To FEMA.
Yeah, go ahead. I don't think it needs to do that, but
yeah, in order to change that, or the other method is that we can act on it and agree with the engineer that the floodplain, regardless of what the firm map says, that the floodplain is contained within the canalway. I would just like to make a comment that I agree with you that and we've seen this over and over again, that the floodplain is contained within the canalways, provided the gates stay closed. And everything stays up in the Merrimack. But once, once the gates, and I believe it's the Francis Gate, and all that water comes into the city. So, it's dependent upon that, but that is a vital part of the flood control measures, and it's not just this site, it's all over the downtown area of the city.
that's correct.
So as a jurisdictional matter, I would like to entertain a motion either that we agree with the engineer's characterization that the floodplain is contained within the canalways for this particular project, and not to extend to any further characterization of this site, just for for this particular stub of the project, and that the firm map shall not be the controlling characterization of the 100-year floodplain. Or that the firm map, that the site is, and that the applicant would have to then provide cuts and fills based on any filling he's proposed, or topography changes that he's proposing on the site. But and actually, could you address that? Are you changing the elevations to any significant degree?
No, we're really not. I'd have to take a closer look. Well, the interesting part is the floodplain is out in this area where, you know, because what
That's
they did
the
is-
high point of the site,
That's
isn't it?
right, it's a high point of the site, but that's where they drew the line. So that's where you look at it and say, well, somebody just rounded it off when they drew it. And so it is the high point of the site. The body of the parking lot is staying just about at grade. I believe that 90, yeah, you know, I'm hitting existing grades. I may be changing things an inch or two, maybe half a foot here and there, but we're talking very, very little minor changes to the grading of the site. If anything, we're pulling everything back into this center, and I'm trying to meet the existing grade along the edges, because I've got, you know, this land is owned by a National Park Service around the edges, so I need to meet that grade. And then just looking at this grade very quickly, I got elevation 92.8 here, and I see an existing of 92.7, so I'm literally filling it a tenth of a foot. Same thing in this area. I get 92.4, and I'm about 92, so it might be 3 inches of fill in that area. So very, very minor stuff.
All right. So, do we have a motion to either accept the characterization that the floodplain is contained within the canalways, or not?
So moved.
Second.
Any further discussion? All in favor signify by aye.
Aye.
Any opposed? The ayes have it. Okay, now moving on to the notice of intent itself. I guess I want to just discuss it amongst the commission members whether or not we want to, we want more information with respect to snow storage and any sort of modifications. I mean, we can make that part of the order with respect to the, you know, making a permanent condition that we shall revisit this project, you know, before any COC issues, in order to determine whether or not, you know, whether this is to remain a permanent structure or whether it's to be redeveloped as intended at this point in time. But do we need language, and do we need to see any areas set aside and any controls put in place for snow storage at this point in time?
I would think that we could address it through an order of conditions, and no need for further iterations through the notice of intent.
All right, Commissioner Chaluka?
I agree.
All right, Commissioner Barnum?
I think the snow storage should be indicated so that it doesn't end up in the canal.
Commissioner Mellon?
I agree.
Commissioner Lynch?
I agree.
All right, can we do that and accept that? Are we satisfied that we can do this after? We can issue a order of conditions tonight with the a condition that the applicant provide us with snow storage plan and area. All right, do I have a motion to close the public hearing then?
Motion to close the public hearing?
Second.
All right, do I have a motion? Oh, all in favor?
Aye.
Aye.
Opposed? The ayes have it. Do I have a motion? I can't make it, so someone's got to make it.
I move to issue a standard Lowell order of conditions on this project with the additional condition that submission shall be made by the applicant for an indication of where snow storage will be occurring. And another additional condition that before the certificate of compliance issues, that the applicant shall determine whether or not this parking lot is to remain permanent or will be removed at some point, in which case further work may be required concerning berms or curbings. And a third additional condition that no salt shall be used in this parking area, and that signs shall be erected in appropriate places to notify maintenance that this is the case.
Do I have a second?
Second.
Any further discussion? Commissioner Lovely?
Aye.
Commissioner Chaluka?
Aye.
Commissioner Varnum?
Yes?
Chair, yes. Commissioner Mellon?
Aye.
Commissioner Lynch?
Aye.
All right, all in favor, it's unanimous. And don't run anywhere, because you're up next. If I can find my agenda, here we go. Moving on, notice of intent. Does anyone want to take a break for a couple of minutes, or before we move on? Or we want to just plow through this? All right. All right, moving on, notice of intent. Hank Keating, DBA Trinity Freudenberg Limited Partnership concerning DEP file number 206-0679. Project location is 110 Canal Street, and it's a building rehabilitation and associated site work within the 100-foot buffer zone to an inland bank to the lower Pawtucket Canal. And Mr. Ware, if I could have you identify yourself for the record.
Hello. Oh, good. I'll give a more abbreviated presentation on this one. This site is 110 Canal Street. It's directly next to the parking lot. And again, my name is Charlie Ware, for the record, Meridian Associates, civil engineer for the project, and I have with me this evening Larry Sparrow from Trinity Financial. Trinity is the applicant. The owner of the property is the city of Lowell. What's known as the Freudenberg building is 110 Canal Street, and this project is essentially the reclamation of that building. We are proposing, I think I outlined the stormwater management provisions in some detail in the last presentation. There is the only piece of new pavement on this project is to the east of the building. You can see the gray area. There is a proposed kind of a driveway access that runs down in there. We are proposing one more. It's a storm scepter that's being proposed to capture runoff that is going to be in that area, and that will drain back into the drainage system, which runs right through the middle of the driveway area. We're also proposing a green roof for this building. I think 1/3 is required, and we may even do larger than that, but 1/3 of the building minimum will be a green roof. The stormwater management provisions are the same as the last presentation, and the standards have been met. The issue of infiltration, no infiltration because of the contamination on the site, but we do meet the 80% removal rates, and have provided operation and maintenance for both long and short term. This is certainly a redevelopment project. The only the only standard not being met is standard number 3. This one is not too terribly complicated. I think there was a little bit of confusion getting to Mr. Thomas's comments. There was a little bit of confusion about the driveway access on the right-hand side. That is proposed and it is permanent. It's not a temporary, it was never intended to be grassed. I was looking at the notes today and I can see why he misunderstood. But that is a permanent fixture that would run with this building, so there's no grass proposed in that area other than the vegetation which is proposed around it, which would be grass. Larry can, if you're interested, Larry can give a brief presentation on how, when he reclaims this building, we're going to keep debris from getting into the canal. As you may know, Larry was the construction super for the Appleton Canal project, which was just recently completed. So he has some expertise in accomplishing that, if you wanted to.
I could just speak louder and so I can see it. Oh, if you want, it records. Okay. The basic scope of this job, I think we're all familiar with it. When we started the job, this was the nicest building on the site, and it is now quite the eyesore. We're actually proposing to bring this back to its historic shape of before it was added on to in height even. We're going to pull that old tin roof off and bring it down to the old roof line. Pull out all those block infills and fill it with storefront glass and fix up the existing concrete. Fortunately, the concrete is in great shape. It's a good, strong building. This will be an office building. It's not residential. And we have 2 prospective tenants actually lined up. So our financing is coming together. It's not 100% there yet, but we're hoping to get started possibly this fall. I think our anticipation is. Through that work, I mean, this side here is land bound, but you can see here where the canal is. We will be building outriggers. There's some low windows, so we put outriggers out and build platforms to collect any potential debris that may fall. We usually pull in, everything gets pulled in, but that's not to say a little bit of doesn't fall down. And we put outriggers out, and actually at Appleton, we created almost like with rubber roofing, a dam there to collect any debris very successfully. So we would propose the same thing for the renovation of this building.
Is it at all possible to put, when you put the outriggers, to curtain the outside of the work area, so when you're doing the removal of the, I'm probably mischaracterizing it, but there's got to be some sort of sheeting over the old brickwork that...
I personally don't think that's required. It's block, and when we pull it, we'll do all the internal demo before we do the external demo, so that keeps any of the major debris and dust. We'll be doing sandblasting and getting the paints off the walls on the insides, so we're going to want to keep that existing building envelope in place. And then when that's done, then we pull that block and the old windows in. I don't see that having a lot of dust being generated from that. And then also particularly over the canal, if that's the concern, is there's no real good way to create scaffolding and netting. We'll do that when we do exterior masonry sometimes, but in this instance, that I don't think will be, it's not contemplated at this time, let me say that. I think if we got into a condition with the subs and we feel like it is creating a dust environment, then we would take appropriate action.
The debris that comes out of the building, I'm assuming that this building as it exists now is completely unsuitable for, other than its structure, for its ultimate intended use, the build-out that you're proposing.
Yeah, it's a gut rehab. Everything on the interiors will be pulled out.
So there's going to be a lot of debris removed from...
Yeah, although it's actually relatively clear inside. There's some piping and stuff. Actually, there's not that much asbestos in there. Most of that has been removed.
What's on the outside walls to that building?
Block. It's a concrete structure, skeleton, and then there's block infills, and then there's smaller windows within that block infill.
And those are all
That's
just
going to be all
plastered
pulled.
over or something like that at some point?
No, we're going to pull all that out. So all that's left is the concrete structure, and then large panes of glass basically are put in.
All right. Okay, the pavement, that driveway area that you're proposing, that's, I'm assuming, for a loading dock or something like that down below, or?
Yeah, it will be a combination of entrance in to the lower area, which will service...
For the other buildings that
Well, in a combination, but for the Freudenberg or 110 Canal, it's to get into the lower level of that area as well, and that's where our trash and stuff will be taken out. Also, it will be a future driveway for the parcel, which we call Parcel 9, for the building on the other side that hasn't been built yet.
That's a fairly steep slope.
Yes, it is.
Down into the canal area. What sort of protections are you proposing so we don't get the proverbial truck in February sliding down the ice and into the canal with its 200-gallon gas tanks or diesel tanks, creating an environmental hazard?
We're putting bollards in. I don't know. I don't mean to make a joke, but they better not, because they'll go through our electrical transformer before they hit the canal. So we will have all interest in putting good heavy bollards there to protect that.
All right. Okay.
Right.
All right. I don't know.
And actually, Charlie, it's mostly passenger vehicles at that point. The trash and stuff will be brought up.
That could potentially even be worse, so.
Yeah, less careful.
Yeah. So, all right. I have no further questions. Commissioner Chalupa, Commissioner Varnum, Commissioner Mellon,
No question.
Commissioner Lynch.
What do you plan on doing with the debris that you're taking out of the building? Is it going to be staged somewhere, or is it going to go off-site daily?
Yeah, we have dumpsters, and that goes off-site. We probably pull out 4 or 5 dumpsters a day, actually, when we're getting going. And the demo contractor, believe it or not, they go to facilities at Appleton Mills. I think they showed that they recycle like 92% of the material, through their separators and stuff.
Without any further questions from the commission, I'd like to open this up to the public. Is there anyone here who would like to offer their comments or concerns either for or against this project? Kindly identify yourself for the record.
Mr. Chairman, members of the Conservation Commission, for the record again, my name is Mark Goldman, 58 Oakland Street, Lowell, Mass. I wish to be recorded in favor of this, along with whatever set of standard conditions that you may propose. This is an excellent project. Again, this is part of the master plan, as I mentioned earlier, and urge that it be unanimously approved. Thank you very much.
Thank you, Mr. Goldman. Chair notes that there's no one else here to speak either for or against this. Do I have a motion to close the public hearing?
Motion to close the public hearing?
Second.
Seconded by Commissioner Mellon. All in favor?
Aye.
Opposed? The ayes have it. Do I have a motion to issue an order?
Motion to issue a standard order of conditions?
Second.
Any discussion? All in favor signify by aye.
Aye.
Any opposed? The ayes have it.
Same comment applies on Dutton Street.
Yeah.
All right, thank you. And yeah, stay here. Final item on the agenda for this evening is a request for certificate of compliance, Trinity Hamilton Canal Limited Partnership concerning DEP file number 2060640. And the project location is 147 Canal Street, formerly 219 Jackson Street, and it's concerning the pedestrian bridge. And Mr. Ware, if I could have you identify yourself for the record.
Again, my name is Charlie Ware with Meridian Associates, civil engineer for the project, and I have with me Larry Sparrow representing Trinity. I certified that the site was in substantial conformance with the order of conditions. During the site walk, the commission did have one issue regarding signage for to assure that salt would not be used on the pedestrian access to the site, pedestrian bridge. And I'm going to turn that over to Larry because I think he's got a sketch on that.
Yeah, I guess that was my oversight not to have realized I should put a sign up there. I did forward onto Mr. Thomas and to Stephen Stoll this afternoon. I had my sign people make up a little sign. I've actually put this temporarily on the building, but we will make a nice sign that says this. And instead of putting it on the cast iron fence that we just finished renovating, there's a little area of brick wall there that I think I'd like to put this on. I think it'd be a little more appropriate. So just, if that fits.
Are you all set?
I guess so.
All right, I'd like to make a comment that we went out, several members of the commission went out for a site visit yesterday. Seems so long ago now. I was very impressed with the work that's occurring on that site. We encourage people to get out there and look at it because it's turning into, what was formerly a real blight in the downtown area, and it's turning into be a really, really, really nice area. And if the site progresses out to its ultimate goals, that'll really be a jewel in the downtown area, along with, some of our other recent developments over the last couple decades that happened, and to meet them in with the other historical buildings that are in and around the city. So the attention to detail and the professionalism and the work that's gone on is from a resident of the city is much appreciated, but also it's just, I enjoyed being out there, and you want to go back and visit it. So I'm sure that the people that are going to be working there and living there have a real first-class enjoyment of the city from that point of view. So I have no other comments other than that I'm satisfied that we could issue a COC in this particular matter. So
I move to issue a certificate of compliance on this project.
I have a second.
Second.
Any discussion? All in favor?
Aye.
Any opposed? The ayes have it. Thank you. Craig, do we have any other business? Because if we do, I'd like to put it off until the next meeting unless it's critical.
No, we have no other business at the moment.
All right. Do I have a motion to adjourn?
So moved.
Seconded by
Second.
Commissioner Chalupa. All in favor?
Aye.
Opposed?
Aye.
The ayes have it. And we have a couple things to sign before you leave. Good night.
Thanks for the kind words, Mr.
Keep
Chairman.
up the good work, guys.